Good morning, everybody, and we're going to start our meeting with a subcommittee as we wait for a couple more members to get here.
Mr. Dickinson is first.
Oh, okay, Mr. Dickinson is first. Where's my line up here? Oh, here it is. Is it signed in order?
Yeah. So
Okay.
item number 4.
Okay, got it. We're going to start with Mr. Dickerson, item number 4, AB 1655. Welcome, Mr. Dickerson.
Good morning, Mr. Chairman. I start the morning easily. Thank you, Mr. Chairman and members. I'm here this morning to present AB 1655, which we have called the State Employee Bill of Rights. This committee is familiar with many of these issues, so I'm not going to spend a great deal of time describing what's in the bill. I just wanted to highlight a couple things. First of all, I think that the general approach of this bill is to try to take some basic items which I think deserve to be recognized with respect to the employer-employee relationship and to codify them. Some might say that some of these items are contained in MOUs or collective bargaining agreements or in the practices the state has adopted, but those can change. Every time they are subject to negotiation or to a new administration, those items become mutable. And I believe that the items that we have incorporated in this legislation are of a character that they deserve to be preserved, and so I propose to do that by codifying them. Let me just say a couple things about two or three particular elements. One of the provisions of this bill that's raised some attention, has gotten some attention, is the one that would allow state employees to essentially be first in line for work that's available. And some have suggested that would limit or curtail the state's ability to contract out. I don't believe that's the case. We have separate statutes that govern the conditions under which contracting out can occur. But I would also note for the committee, a couple weeks ago in Budget Sub 4, which I'm a member of, as is Mr. Allen, we heard testimony from the Department of General Services, which told us that it is only on rare occasions that a State Department will justify contracting out on the basis of it being less costly to the state. Typically, the conditions under which contracting out occur are when specialized expertise is needed, when it's a temporary or emergency condition. This legislation does not affect in any way the ability, in my judgment, the ability of the state to continue to contract out under the existing statutory framework. Another aspect of this bill that's receives some attention is that which would govern the time within which a state agency has to present a state employee with the results of any investigation regarding fraud, embezzlement, or related kinds of alleged transgressions, and reduce that time. There's a very simple reason for that. It's currently 3 years, and what we have seen is numerous instances in which a State Department will delay, for whatever reasons, its own investigation, will essentially leave an employee twisting in the wind for a 3-year period. That to me is unfair. But more than that, it's also counterproductive, clearly, in the workplace. If there are allegations of inappropriate or illegal conduct, then the investigation ought to be, in my judgment, undertaken promptly, concluded expeditiously, and the matter resolved in a timely manner that keeps the workplace functioning smoothly and resolves the issue among the parties. Those are the two aspects of this I wanted to highlight. Beyond that, there are a number of other, I think, very basic protections that almost anyone would expect in a workplace, and I would be happy to discuss those if you wish, but other than that, I would respectfully request an aye vote, and I have some witnesses here with me.
Assembly member, let me put you just briefly on hold. I have a quorum, and I want to take the roll. Could you do that, Wendy?
Furutani.
Here.
Mansour. Here. Allen. Here. Harkey. Ma. Wykowski.
Here.
Could I also do the consent calendar, because Mr. Wykowski has to run to another committee and then come back. Can I do that now? So let's move the consent calendar.
So moved. Or second. I'll second it. I need to second
Thank
it.
you. Roll call, please.
Furutani.
Yes.
Furutani, aye. Mansour. Aye. Mansour, aye. Allen. Aye. Allen, aye. Harkey. Ma. Aye. Ma, aye. Wykowski.
Aye.
Wykowski, aye. Consent calendar is out.
Thank you very much. Thank you, Bob, and we'll get your bill when you come back. I'm sorry, Roger, we just wanted to take care of that real quickly. Yes.
Absolutely. If I may, Mr. Chairman, just one final comment. I'm sorry I omitted before the witnesses testifying. That is, there have been some issues raised by stakeholders who have some concerns about clarity in the language. I want to make this public commitment to continue to work with them to refine the terminology in the legislation to address those issues. And with that, I ask my witnesses to briefly testify.
Please go ahead.
Mr. Chair, Randy Cheek with SEIU Local 1000. We're one of the co-sponsors of this legislation. We just want to simply point out that this extends the same kind of protections enjoyed by other state workers, such as peace officers and firefighters. They already have many of these protections, and we're just extending it to all public employees. We also want to show that this is a cost-saving measure by requiring the use of state employees over outside contractors. And as you know, we've done a lot of research on this where we can prove that outsourcing actually costs the state a lot more money. In addition, AB 1655 also bans work created by vacancies, furloughs, or layoffs without fair compensation. And it sets the one-year time frame, which Assemblymember Dickinson has already testified to, that this is also a cost-saving measure, because after 3 years of waiting and waiting and waiting, you know, this does cost the state an excessive amount of time and money. So for those reasons, we are co-sponsors, and we would appreciate your aye vote.
Thank you. Morning.
Good morning. Sherry Golden, representing the California State Employees Union, CSU-EU, and we've been working with the author, and we just would like to be included in the bill because we think it's an excellent piece of legislation, and we worked on the one for the supervisors because I represent the supervisors, and it's done some good as far as the meet and confer process. So we think that the author is going in the right direction, and we would appreciate your support. Thank you.
Thank you.
James Norman on behalf of ASME Local 2620 and the Union of American Physicians and Dentists. We are co-sponsors with the bill with SEIU 1000 for the reasons previously stated, also for the reason that this bill would establish a peer review process for our physicians within the state service. It's important to make sure that our physicians are taking directions from their peers who are other licensed physicians instead of taking their directions from management. And we just think that's good public practice, good public policy, and cuts down on the liability concerns. We ask for your support of the bill.
Witnesses for?
Pat Whalen on behalf of California attorneys, administrative law judges, and hearing officers in state employment in support of the bill. We are working with the author's office to clarify that the bill will apply to employees at the State Compensation Insurance Fund, and we'd echo the comments of Mr. Norman. On behalf of all the attorneys in the state, we have ethical obligations and have to follow the rules of professional conduct. It doesn't happen often, but every once in a while, one of our attorneys will ethically be required to differ with management on a legal issue, and their job shouldn't be at risk when that occurs. So we support the bill. Thank you.
Other witnesses for? Witnesses in opposition? Let's make room for it. Oh, there you are, Ryan.
Good
morning. Jennifer Brewer on behalf of the California Chamber of Commerce, and we are opposed to this bill, given the concerns of the disadvantage it would place the private sector contractors at and the increased pressure on the state budget with regard to increased personnel costs. The hiring preference that it provides for state employees to fill overtime, permanent, and part-time positions would put disadvantage private sector employees who could contract with the state. And although it may not happen all the time for cost-efficient reasons, even expertise and skilled contractors, when the state contracts out, would be at a secondary preference given state employees who could be trained or hired to fill the position instead. And so we're concerned with the impact on the private sector contractors. We're also concerned with the increase in personnel costs similar to the bill last year. We disagree that this would be a cost-saving measure. I think that the bill last year in appropriations was said it could increase personnel costs by $100 million. There are some ambiguous terms in here, such as you can't compel unreasonable quotas or extra work to be performed without fair compensation. Those are ambiguous terms that could lead to differing opinions as to what that means. So you could either result in litigation over what that means or even increase personnel costs just to avoid that type of differing opinion. And so we're concerned with the additional costs this would place on the state budget. And for those reasons, we're opposed.
Thank you. Any other witnesses in opposition? Members, questions? Yes, Mr. Wachowski.
What's included in notice of adverse actions? We use this term of art, notice of adverse actions, when we're going to reduce the time limit from 3 to 1 year. But is that a lawsuit? Is that a letter? I'm not really sure what's included if somebody's accused of embezzling from the state.
Well, if you have embezzlement, that's a criminal action. But we do have cases where accusations are made against employees for could be conduct. It could be they didn't do their workload. They felt that there was a workload issue, something like that. We've had cases, and I can think of one in particular, where someone was accused of going back 3 years. Well, your workload was, even though this was an exemplary employee who had received honors. She was accused of, 3 years ago, we found out that you didn't meet your workload quota, and they took adverse action against her.
So the notification could include, it's not, fraud and embezzlement always catches people's attention. That's a complaint that's filed, or it's a complaint that's filed by the district attorney. But there's a whole other variety. When you say a notice of adverse action, that doesn't have to be a civil suit. That could be an internal action. So it's just, and is it certified notice? Is it hand delivered? What's that magic event that has to occur within a year? And I guess that's my question.
In some cases, there are certified notices. In other cases, it's just, they have been brought in by their superiors and action taken against them.
So it doesn't actually mean that you have to, it's just a notification. You don't have to commence, or is there an administrative commence action that is included in this umbrella?
The administrative would be included. In other words, one of the reasons we have put this in here is because we have found that when we have members who become very active, who become stewards and start working to create a harmonious relationship in the workplace, sometimes actions are taken against them. Mm-hmm. And it can be minor. And, they'll stretch it out 3 years to do a hearing or to do an investigation, and we feel that it can be done in 1 year and should be done in 1 year.
And I presume that adverse actions other than embezzlement, fraud, or falsification of records already have a 1 year time limit.
No,
they don't. Okay, so is there anything that has a 1 year time limit right now anything with this group of employees?
To my knowledge, no.
Okay.
Doug Chiappetta, Union of American Physicians and Dentists, would ask me. My colleague Sherry Goldman has just informed me that we're in strong support of the bill. That peace officers, I believe, have 1 year limitation on the adverse action process.
Okay.
So it's already in statute for peace officers.
Members, other questions? Mr. Allen?
Yes, thank you for bringing this bill forward. I do support it, but I have just some questions. In a way, it's almost an omnibus bill because it's affecting so many different public employees, and I just am hopeful that because whether it's attorneys, accountants, you name it, that basically that there's enough dialogue going on with all the different professions, so that if there are peculiarities for those particular professions, that somehow it's either incorporated into the bill or taken into consideration. I guess the other thing I'm concerned about is that sometimes there's a mention of a right, and sometimes it's very specific in the bill that it's tied to a federal or state law, and other times just enumerates the right. And so I don't, that's really, I guess, up to the drafter of the bill as to how specific you want to go when you decide to tie things to specific legislation or not. But, that would be a concern of mine. And just going back to my initial point, I just want to make sure that if there are particular oddities out there where particular classes have been excluded from these kind of rights, to make sure that somehow we don't have to come back with cleanup language to capture them. So that'd be one of my concerns, but I certainly support the bill and your intentions.
If may, Mr. Chairman, thank you for the comment, and we're very actively working because there are some nuances to this, given different professions, different job categories and classifications. So I don't see anything so far that is insurmountable in terms of addressing those. But I think as we go, we will make sure that we refine those issues with respect to affected parties.
Yeah, and just one other comment. I noticed that you included the right to overtime and the right to available work. I'd just like to point out to you that in some of the areas where employees work in the state, there may well need to be a right to refuse overtime for safety reasons. I know in the state hospitals, for instance, people always are calling me and complaining about having to work unreasonable shifts and unreasonable hours when they don't even feel they are safely able to work. So it's just something else to consider.
Thank you. Good comment.
Members, other questions? Can I get a motion? Moved. Second. Thank you very much. Roll call, please.
Furutani?
Yes.
Furutani, aye. Mansour? No. Mansour, no. Allen? Aye. Allen, aye. Harkey? Ma? Aye. Ma, aye. Wykowski?
Okay, this bill is on call. Thank you very much, Assemblyman.
Thank you, Mr. Chairman.
Next, we'll hear item number 3, AB 1606, Assemblyman Perea.
Mr. Chair and members, thank you for allowing me to present AB 1606. I will be very brief. AB 1606 is a cleanup measure that would clarify that fact-finding is available to employee organizations in all situations, regardless of whether the employer and the employee have engaged in mediation. As you may recall, the legislature passed AB 646. The governor agreed with the legislature by signing this bill into law, and it strengthened collective bargaining by improving impasse procedures that are governed under the Brown Act. However, since then, there were some issues in terms of how AB 646 was to be implemented. So last December, PERB adopted emergency regulations allowing fact-finding to be requested in all circumstances. So AB 1606 seeks to codify that decision so that it's clear in statute that this was always the intent of the legislature to move forward in this direction. I'm proud that AB 1606 is co-sponsored by AFSCME, SEIU, PORAC, and the California Professional Firefighters. And with me today, I have Janice Norman, legislative advocate for AFSCME, who's here to testify in support of the bill.
Good morning, committee. Janice Norman on behalf of the American Federation of State, County, Municipal Employees. As the Assemblymember correctly stated, this is a cleanup measure. It makes it clarifying the intent of the legislature to strengthen impasse procedures and not allow them to be gutted. Without the passage of this bill, it is conceivable that you can have an employer refuse to go to mediation and therefore attempt to avoid fact-finding and therefore directly impose its last, best, and final offer. Clearly, that was not the intent of the legislature. The legislature wants to make sure that all processes and procedures are in place for collective bargaining to move forward in the most fruitful manner, and so we respectfully ask for your aye vote.
Mr. Chair, members, Randy Perry with Aaron Reed and Associates on behalf of PORAC, co-sponsors of the bill.
Thank you.
Mr. Chair, members, Christy Valma with the California Professional Firefighters, also co-sponsors.
Libby Sanchez on behalf of Labor's Local 777, not a co-sponsor, but a huge supporter of the measure. The measure not only comports with the underlying intent and spirit of last year's AB 646, but also with the underlying Myers-Milius-Brown Act. For those reasons, we're in strong support.
Michelle Cass with the Service Employees International Union. I just wanted to build off something that Mr. Norman said about an employer could unilaterally impose without going through the whole good faith process. That's not a possibility. They have been doing that since AB 646 has passed. So this bill is very necessary to stop that kind of unfair practice going on in the future. Thank you.
Mr. Chair and members, Caitlin Vega for the California Labor Federation. We are here in strong support. We think that this bill promotes labor peace, promotes harmony between management and labor, and steers us away from some of the more aggressive moves that we're seeing taken up and down this state. So we're here in strong support. Thank you.
Any other more witnesses in favor? Opposition? Witnesses in opposition? Welcome.
Mr. Chairman, members, good morning. Brian Lundgren on behalf of the Orange County Board of Supervisors, which respectfully opposes the bill. The county believes the bill will take discretion away from the Board of Supervisors as they have right now and put it into the hands of the fact-finding panel. The bill appears that would be applicable to both formal contract negotiations and meet and confer process involving changes to department and agency county operations. This broad criteria, the board believes, will give substantial authority to the panel and give the panel to consider factors not normally considered by the county as being relevant to its operations. Many county departments implement operational changes right now to gain efficiencies and/or lower costs to its employee and county process through the meet and confer process, and the county believes this bill will significantly impact those proposed changes, and so the county respectfully opposes this bill. Thank you.
Any more witnesses in opposition? Members, questions? Mansour? None? Yes, go ahead, Mr. Allen.
I do support this bill, but and maybe this isn't a question that can be answered today, but maybe the staff could look into it, is that I'm just wondering, as now that we're asking for improved procedures for impasse and fact-finding, whether we have the resources, like in state conciliation and mediation, to actually do the work, because I know a lot of the local jurisdictions are doing, negotiations around realignment, pension changes, all those things, and I just want to make sure that if we're going to pass this bill and go forward, that we have the resources to actually implement it. So that'd be my major concern. Not so much a question for the author, but just something to so note, because sometimes we talk about these things and we just assume there's the resources out there to get the job done. But thank you for bringing the bill forward.
Sure.
Any other questions, members? Can I get a motion, please? Moved by Mr. Allen, seconded by Ms. Ma. Thank you. Roll call vote, please. I knew she was going to second it.
Furutani.
Aye.
Furutani, aye. Mansour. Mansour, no. Allen. Aye. Allen, aye. Harkey. Ma. Aye. Ma, aye. Wykowski.
It's on call. Thank you very much, Mr.
Thank you very
Correa.
much.
Number 6, Mr. Alejo, AB 1908.
Good morning, Mr. Chairman and members. I'm going to present, but for questions, my staff will have to take over because I got to go to a meeting right after this.
Got it.
All right. Thank you. Well, good morning. I'm here today to present AB 1908, Reasonable Notice for School Employees. California's budget crisis is so severe that layoffs have become inevitable for many school districts. AB 1908 seeks to address an inequity in law regarding school employee layoff notices. This measure makes sure that when school districts are confronted with challenges in balancing their budgets, they do it in a fair manner and not on the backs of workers who are struggling to make ends meet. Classified school employees, as you all know, include our secretaries, bus drivers, food service workers, groundskeepers, custodians, maintenance workers, para-educators, and healthcare assistants. They are the backbone of our schools. Workers in school cafeterias play a critical role in the education of our children. Our school maintenance crews ensures that our schools are safe and comfortable places for students to learn. And our bus drivers make sure our kids get to and from school safely. However, existing law treats our classified employees' rights and opportunities as less important. Teachers and administrators currently receive significantly more protection and are required to receive notice for layoffs by March 15th. But no similar protection exists for classified school employees. Changing the layoff notice period from 45 days to 60 days will allow employees more time to find new jobs, address child and healthcare issues, and move to a new home if necessary. The additional 2 weeks of notice will now require school districts to employ classified school employees for additional days. It will simply require them to plan further ahead, something they already do for teachers and administrators. AB 1908 is a just and reasonable measure to protect working families during the current budget crisis, and I ask for your aye vote here today.
Good morning.
This is for.
Good morning. My name is Dolores Strand Flores, and I'm with the California School Employees Association. We are co-sponsors of this bill. This bill is a simple bill, simply extends the notice for layoff from 45 to 60 days. It may not seem like a lot, but it's actually crucial in the lives of classified employees. We've also brought with us one of our classified employees who works locally to give you the perspective from them as to why this is so needed. So I'd like to introduce Carol Johnson.
Morning.
Good morning, Mr. Chairman, members. My name is Carol Johnson. I'm going to read this or I'll fall apart. And I'm a special education paraeducator. I work with severely disabled students at Samuel Jackman Middle School in our Elk Grove School District right in South Sacramento. I am a classified employee. I'm here today on behalf of the California School Employees Association. CSEA represents 210,000 members like me across this state. AB 1908 is CSEA-sponsored bill, and it is a very modest bill that it'll have a huge impact on the lives of our classified employees who are being laid off. As AB 1908 is simple but is so important to us, it just provides an additional 2 weeks of notice to help us prepare for a major disruption of our lives, in the lives of our children and in the lives of our families. This time is needed to help us find a new place to live, enroll our children in a new school, to secure health insurance, and start looking for a new job if this happens. Sadly, over 30,000 of us have been laid off over the past 3 years. And I got to say off the record, I'm missing a layoff meeting right now in Elk Grove with 27 of my people, so the notice needs to be put out ahead. Being laid off is a devastating experience. It's even worse if you are a head of the household. 75% of our classified employees are women. Many of them are caring for their children singly or their grandchildren, and this bill is about them and it's about me. AB 1908 provides a lifeline for us and a bridge between our jobs as we're being laid off and preparing. I'm a single widow at this point, and I sure don't make enough. I earn $23,000 a year. That's less than $2,000 a month, and that's before taxes come out. After I pay my mortgage, my insurance for my house and my car, all my utilities, SMUD, PG&E, water, sewer, garbage, and phone bills, and buy groceries, there's very little left. I don't even want to think about emergencies that come up. The other classified employees that I work with have similar stories. And so you see, we're already living on the edge, and we really do need that extra 15 days more notice to be able to plan out. It isn't hurting anyone. A new job doesn't happen overnight. And for going to an employer, it takes at least 60 days out to do an interview process, first off with the application and your screening and the interview, and for most of them, for the employers. We believe AB 19 is modest and greatly needed. On behalf of our classified school employees across California, I ask for your aye vote. Thank you.
Thank you.
Hi, Dolores Sanchez, representing the California Federation of Teachers, and on behalf of our classified school members, we're here to support this very important bill. And I just, this is a matter of equity, in terms of looking at how we treat other school employees. And it's a matter of equity for, as the witness said, this is, these folks are the lowest paid school employees, and as such, they have the lowest pensions, and they have the fewest resources. So we ask that you support this bill.
Mr. Chair, members, Caitlin Vega for the California Labor Federation. I'm just so struck by the figure that 30,000 classified have been laid off in the last 4 years. And as we struggle to try to rebuild our economy and to create jobs in the private sector, we have to consider the offset to that's happening in the public sector with this tremendous number of layoffs. Mrs. Johnson's testimony was so compelling. I would just add that as a parent, I have seen the impact of losing classified staff from the classroom. I think that this bill will be helpful to schools in preparing the teachers, the parents, the children for these kinds of changes, because they can be tremendously disruptive for everyone in the classroom. Having more time to plan and more time to prepare, I think, is good for the workers and good for the classroom environment. So we're here in strong support. Thank you.
Thank you.
Libby Sanchez on behalf of Labor's Local 777, representing classified employees in Carlsbad, California, in strong support of this important measure. Thank you.
Mr. Chair, members, Christy Balmer representing the California Professional Firefighters in support of our brothers and sisters and the school communities. This is an important bill. It's a compassionate equity bill. Ask for your support.
Renee Bayardo, SEIU. On behalf of the classified employees that we represent, we strongly support the bill.
Janice Norman on behalf of the American Federation of State County Municipal Employees in support of the bill as well.
Thank you, Janice. Any more witnesses in support? Witnesses in opposition? On the Alejo bill. Good morning.
Good morning.
He was here.
Okay.
Yes, go ahead.
Mr. Chairman and members, I'm Brian Rivas on behalf of the California School Boards Association. Sorry to be here in opposition to a bill sponsored by one of our partners in the Education Coalition that we're actually working with to try and prevent cuts and additional layoffs. But I want to say that that we agree that the cuts and the effect on our staffs and the schools and layoffs have been devastating, and we'd like them to stop. The reason for my opposition has to do with the fact that, remember that classified employees and certificated employees are not treated the same under the law for the purposes of layoff. Teachers are notified on March 15th of possible layoffs. Classified employees are notified when there's a bona fide reduction or elimination of service. So that means by increasing the notice period, you're increasing the amount of time that people are going to be paid, and that reduces the savings that were sought, that were the reason for the cuts and the layoffs in the first place. So our concern is that by increasing the notice period and the time for which people will be on the payroll, you could be forcing cuts in other areas, or in fact increasing the overall number of layoffs that will be necessary. So for those reasons, we're regretfully opposed to this.
Thank you.
Thank you, Mr. Chairman, members. Jeff Alka, representing the California Association of School Business Officials. Our position is very similar to that of my colleagues. We regret that we're in a situation where layoffs have become increasingly necessary in our school districts. School districts have faced upwards of $20 billion in reductions in the last 4 years. We wish we didn't have to be in a situation where we were laying off both classified and certificated employees. Our concern is that even though a 15-day increase in the notice may seem insignificant, in our view, it greatly reduces or makes more difficult planning and budgeting, a task that is already exceedingly difficult for governing boards, superintendents, school business officers, given the moving target that has become education funding in the state. And I think that this year is a perfect example. School business officials are being told that they are needing to make assumptions about revenues that may or may not be coming in later in the year, and we just don't know if that's going to happen. So it puts us in a difficult position, and we, again, regretfully oppose the bill because we think that adding the 2-week, 15 days notice would make it even more difficult. Thank you.
Any more witnesses in opposition? Members, of course, Mr. Mansour.
To the gentleman that just spoke, I apologize, I didn't get your name, but what you just mentioned about the uncertainty, do you think this is going to lead to more precautionary layoff notices and therefore add more stress to the employees?
Well, I think that would be one of the unintended consequences, as we've seen in the case with certificated employees. The cautious thing to do on the part of school business officials is to over-notice employees. And one of our fears is that is what would happen in this instance, and that, as you said, that is very disruptive.
Other questions, comments? Yes, Mr. Allen.
I'm going to support this bill, but I do understand what you're saying. I'm sure that what happens, and this has already been weighed by the employee representatives working with the employees, that there's always that issue of causing undue anxiety, balanced against people's right to have a little bit more time to plan if, in fact, the layoff is going to occur. And I do understand the issue of perhaps maybe precipitating a little bit more expense, which could have an impact. So I do hear your concerns, but I do think deference has to be given to the folks who represent the workers in terms of talking to them. But I do have one question. It's a very simple question. Reading the language, I'm assuming that because it doesn't state otherwise, when we talk about days, we're talking about calendar days. Is that correct?
Yes, it's calendar days.
All right, thank you.
And can I respond to as well? This came from our membership. We're a member-run organization, and this issue came from them. They think it's critically important that they get the additional 2 weeks. They don't think it's going to cause undue harm. The big thing that we're looking at, too, is that once March 15th is actually gone, my members know they got a huge target on their back. They know they're the only ones that can be laid off going forward any time of the year with just 45 days notice. So that's really what the anxiety is about. But they think they need another 2 weeks at least to prepare to go find a job, to get their house up for sale if they have to get their kids enrolled in other schools. They just don't think 2 weeks is going to, be that difficult, especially since districts are already planning so far in advance for their teachers and administrators. And once that March 15th layoff notice is passed, we know teachers and administrators cannot be laid off for a whole academic year. So we know that a 45-day notice is for our members. That's why we're just asking for the additional 2 weeks. I don't think it's unreasonable.
Thank you.
Members? For myself as well, I'm a school board member, community college member before coming to the legislature. The classified have always been in a position where they're the most vulnerable, particularly during these economic times. The threshold I've sort of reached is it's gone to such a point where layoffs or the question of potential layoffs are something that every school district, community college has said looks at every year. I think your point from CSBA is exactly the point. We got to stop doing the layoffs, period, let alone how to deal with them in terms of time frames, etc. We all know the game on March 15th. Everybody gets a pink slip now. Everybody gets a pink slip. It's getting ridiculous in terms of whether or not it's any way to do any planning. I think we have to look at that question as well in terms of the March 15th notice and what that means. But this issue for me becomes really relevant after you lay off 30,000 already. I don't know how many are left. And so the issue of giving 2 more weeks, not only it doesn't even get anywhere near close to the issue of equity, but it's something to try to be more humane about dealing with this issue of layoffs, which has become a reality in our school districts. And the other point management makes, which is something that is our reality, is this moving target. That's a perfect way of describing what's happening with school-based funding and budgeting, and then now we have trigger cuts and things get done in the middle of the year. How in the heck do you plan? And everybody knows fundamentally our budget system is ass backwards, candidly. I mean, we know what our expenditures are going to be based upon the year before, so July 1st we start spending money, but we don't know what our revenue is. It's all estimates. And you start looking at sales tax, and then our first installment of property tax comes in November. Then we wait to see what the governor's going to say in January with the state of the state. Then we wait for the income tax to come in on the 15th. Then we wait for the May revise. That's as close as we understand what our revenue piece is going to be. All this time we're spending money and trying to operate huge institutions. So in any way we can help out, and I know there's certain limits in terms of having to be flexible and provide that flexibility, but after laying off 30,000, I don't think it should be on the backs of classified. It's got to be looked at in terms of how we can get through this, and I think if this is going to help on the human side, then I think it's worth the effort to try to make this change, and planning is going to have to be, and I know school districts, community college districts, everybody's having to do this crazy planning. I don't know how you plan now, because with trigger cuts and all this mid-year stuff that happens, you just don't know. And when the mid-year cut comes down with only certain people that you can lay off, that's classified. It becomes really a problem for them. So I think in looking at the overall and the broader context, I think this is a bill that makes sense. Maybe we can straighten some of this stuff out as we move forward, but at this point, I'm definitely going to support this bill. Can I get a motion, please? Moved by Mr. Allen, seconded Mr. Markowski. Roll call, please.
Furutani?
Aye.
Furutani, aye. Mansour? No. Mansour, no. Allen? Aye. Allen, aye. Harkey? Ma? Ma, aye. Wykowski? Wykowski, aye.
The bill is out. Thank you very much, and tell Mr. Alejo thank you. Item number 2, AB 1519, Mr. Wykowski, perfect timing.
And then that's it. We just have a couple bills on.
Okay, great. Mr. Wykowski, please.
Thank you, Mr. Chair. This controversial measure has been brought to me. No, it's a narrowly tailored bill, 1519, that aims to ensure that all members of the 37 Act county retirement boards are well educated. It requires each trustee to complete a minimum of 24 hours of education for the first 2 years of assuming office. It also requires a subsequent education for every 2-year period the board member continues to serve on the retirement board. It maintains local control by allowing each of the 20 retirement systems to develop their own education program. I'm a member of the California Bar. I continue, even though I'm exempt, I continue to have continuing education with the bar, and this is hopefully these folks that serve as members of the retirement board will learn some financial tools to serve better. The 20 counties systems manage $80 billion in assets and administer benefits to 400,000 employees. Despite this massive responsibility, trustees of the retirement systems are not required to have any specific knowledge of the financial or investment fields. It might be a good idea for members of the Assembly to have some financial investment information. I'm pleased to have with me today in support of the bill Trent Smith with the State Association of County Retirement Systems and Ms. Christy Bauma with the firefighters.
Yes, proceed, please.
Thank you, Mr. Chair. Members, Trent Smith, representing the State Association of County Retirement Systems, sponsors of the bill. The reason why we are sponsoring this bill is, as many of you know, right now in the retirement world, our trustees have a tremendous responsibility to make investments that best serve our county retirees. And right now, as the pressure to have a better return exists, the investment world is becoming more complex, and there are things like hedge funds and investment instruments like that out there. And at the same time, there are fewer and fewer investment professionals serving on our boards. Most of them are lay people. They're current employees, retired employees. It used to be that we did have financial professionals who served on our boards. It's become less attractive for them to serve on our boards. So we thought right now would be a good time to bring this bill forward. Many of our trustees do attend on their own educational courses or conferences to learn about financial decisions. But we thought that, again, with the circumstances that exist today, it would be good to have everyone meet at least some minimum requirement so that they can best meet their financial responsibilities as a trustee. So we would ask for your support. Thank you.
Mr. Chair, members of the committee, Christy Baumer representing the California Professional Firefighters, also pleased to be in support of this bill. Rounding out Trent's comments, also Board of Supervisors or their staffs are often designees to the board who would equally benefit from this training. They are all charged with being good fiduciaries of members' money, and so this will only serve to enhance the service they provide to that system. We're in support.
Thank you. Other witnesses in support? Opposition? Witnesses in opposition? Members, any questions?
I'll move the bill. Second.
Moved and seconded. Thank you, Mr. Mansour. Roll call, please.
Furutani.
Aye.
Furutani, aye. Mansour. Mansour, aye. Allen. Allen, aye. Harkey. Ma. Ma, aye. Wykowski.
Aye.
Wykowski, aye.
Thank you. That bill is out. We have a few bills on call. Let me take care of those real quick and we'll be done.
You want me to just call them?
Yes, go ahead.
Item number 3, AB 1606 by Perea. Absent members Harkey, Wykowski. Aye. Wykowski, aye. That bill is out.
Okay.
Item number 4, AB 1655 by Assembly Member Dickinson. The absent members Harkey, Wykowski. Aye. Wykowski, aye. That bill is out.
Very good. Thank you very much. The meeting is adjourned.